Good morning. Please be seated. This is the time and date set for cause number CV 190144, Sunburst Firms versus Braden. In an effort to social distance ourselves, Judge McMurdy will be watching via YouTube, and we've got his questions for you written down. So, these proceedings are being video and audio recorded, live streamed as well, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we've read the briefs, have conferenced this case, are familiar with the facts. Please take that into consideration. At this point, counsel, you may proceed.
Good morning, Your Honors. My name is Claudio Iannatelli. I represent the homeowners that have found themselves in the dispute with Sunburst. They're sometimes referred to as the Braden defendants, sometimes the homeowners. Besides our specific legal arguments and factual claims we've made, we come before the court guided by three principles that I think underline most of what we argue. One is that honesty and fair play are not aspirational. Villains are not those who confront tyranny, and the end must never justify the means.
Can we start with just a fundamental question? Where in the record does the literature provided to the homeowners say that a majority means a majority over all sections, not just a majority within the section?
So, specifically, and it's cited in our brief, it's quoted in facts which are not disputed. In two specific references, they identify to the point that in order for the amendment to pass, we need 50% plus one from each section.
But the ballot itself, there's nothing on the ballot itself that says that. I mean, the ballot itself says Section 2 needs X number, Section 3 needs this number. Is there anything in the ballot that says, and unless all of the sections pass, this election will not go, the results will not go into effect?
So, Your Honor, I think I would say the answer is yes, but you have to look at how that is said. Your Honor is correct that the bottom portion of the ballot identifies the votes required from each section without then leading to a conclusion or another. However, what is being voted on and what you are approving is what we submit is the key of how to interpret the ballot. When you go to the question for the proposed action is asking you, do you approve to adopt the revised CCNRs and bylaws that were distributed on 11/1. When you go to that document, how can you understand what you are voting on and what the measure is unless you look at that the document? The document has two specific sections. One that disclaims now all prior recorded deeds, all the prior disputes, the 2004 agreement, the 1985 agreement. It says this document does away with all that. It also says these...
And you're saying that can't be the case if one of the sections doesn't pass?
Correct. And it further states, beginning, this document having been approved by a majority of the owners in each of Sunburst sections 2, 3, 4, and 7.
And I apologize for interrupting, and this may be something that's in the briefs that I just overlooked. Are there other sections in Sunburst that... Is there a section 1? This is the entire group of homeowners in these 4 sections?
As it relates to this Sunburst community, yes. And so the way they numbered them, I'm not really sure historically. There is a Sunburst Estates, but this Sunburst Farms East is these 2, 3, 4, and 7.
And so there's no other section that's currently subject to mandatory dues or who's involved in any way with this irrigation system?
Not involved in any way at all. Okay. And so in addition to this specific reference in the very document that is being put to the proposed action of the vote, when you look at the document itself, it defines property as the entire sections 2, 3, 4, and 7, and it defines owner as anyone within sections 2, 3, 4, and 7. So the document people were asked to vote in is, do you accept one document that will govern everyone equally on the same rules and so that we can achieve unity? It didn't say, let's have a vote so we can have the same dilemma that we've been facing before. It didn't say, let's have a vote so that we can just have people change their rights. For example, something else, the CCNRs now removed the right of any section to independently amend their own CCNRs. Specifically now, when adopted, it requires a majority of all sections, not just individually as was prior to that. Again, how do you achieve that without everybody approving it? Furthermore, while we keep focusing on the CCNRs, the vote was not only on the CCNRs. The vote was specific to the CCNRs and bylaws that were amended to govern pursuant to the CCNRs that were intended to govern every section. You now have a disconnect with bylaws that have no alternate provisions to provide for the eventuality that perhaps not all sections approved. As Sunburst counsel themselves repeated twice in the litigation, it was an all or nothing proposition. Either the amendments would be approved as a whole or not. That's what it was about. That is what every piece of communication was sent to the owners. As I was answering the first question, not only do they say how many numbers was needed from each section, it then totals them. This means we need 145 votes. The wording couldn't be more clear. It was an all or nothing proposition. It's saying...
How can it specify a number of votes if it's a majority? Say it's unanimous in one section and it doesn't...
What it says is, it's again specifically quoted in our brief, but it walks through and it goes, in order to, what you need is...
You're just saying the number can be a simple majority in each, and that's the minimum number of votes.
A majority plus one, so 50% plus one in each section, which totals to 145. The point is, if this was an independent vote of each section, you don't add up the total that is needed from each section. Furthermore, the other specific statements are that by approving the amendment, everybody will share equally in maintaining the water system. Everybody will pay equal to maintaining the easements. All 281 lots will pay equally. It's pointed out in the answering brief that we acknowledge there weren't misrepresentations made by the board. And I want to clarify that. Indeed, that's true, because the board spoke truthfully. The board spoke of what they were seeking was unity. Every fact that we cited in below and repeated in the brief that supports that it was an all or nothing proposition was not disputed by Sunburst.
Well, but the board's seeking unanimity. Certainly that's the goal, but wouldn't the board at least be on board with if we can get 3/4 of the sections to agree, and then there's voluntary participation by the fourth section, that's better than what we currently have? Is it better? I don't know. But aren't their owners entitled to know what they're voting on? How is it that let's be really mindful of what we're saying. We are saying that if you affirm, I submit, Your Honor, if you affirm this decision, you are essentially saying to boards that you can put out information, even if it's what you believe at the time, that explains what the vote is. But then if you don't achieve it, and you can come in and fix the result to something else, and now as a board you decide you like, that's okay. There's no other way of saying it. You cannot look at the information that was submitted and reach any other conclusion. This was an all or nothing proposition. There is no in between.
And your best evidence of that is the CCNRs themselves, the bylaws. Is that correct?
That is directly attached to the ballot? Yes. But you can't ignore all of the communications that lead up to the point of the election. I mean, those other communications came as part of the communications, presentations, and package. And whether you're looking at contractual interpretation of voter law, the same result applies, which is you have to look at the pamphlets that were distributed to people. What are we voting on? I keep harping on that, but it's fundamentally fair. You know, just dating back to days of childhood, hey, I'll jump if you'll jump. That's different than saying, hey, fool, why don't you jump? Okay? I mean, it is fundamentally that basic. This community was in disarray due to the lack of unity. So a group that wanted to change set out to say, let's make it same for everybody. Let's unify everybody. Will you support this amendment as long as everybody else will be subject to it? And so if I'm voting, I say, look, I don't like it. In fact, you see the ballot we included in the brief itself has language to that effect from one of the individuals. But look, maybe nobody really likes it, but if we can all stick together and we will all have a proposition that everybody is subject, will you support that? That's an entirely different question than saying, hey, Section 7, do you think you want to get stuck with it even if nobody else is? Those two are not the same. And we're not challenging the fact that they could have had an election where each section voted independently. We recognize they could have. But because they could have doesn't mean they did. The fact is they did not.
Sunburst does suggest that there's no evidence that anyone who voted yes has indicated that they were misled or wanted to change their vote. What's your response to their argument that you would in effect be disenfranchising the people who voted yes without any indication from them that they were unhappy with the result?
That they could have their own election subsequent to the one that was lost to vote on their own section, which they did not. That the response says, don't challenge the vote, the
but
right of...
it didn't lose in those sections, though, I guess is their point, that there was a majority in these sections who said, yes, we're willing to do this.
But, Your Honor, you can't get there unless you ignore the question. The question was, will you support this amendment if everyone else supports it and it will be subject to it? And whether or not, look, somebody who voted yes, why would they come forward? Number one. But I'm entitled as a voter who voted no to say, that's not the question. You have now recorded a document that has a disconnect to what was voted on. What gives them the right to approve a document that removes Section 7? And so now you leave Section 7 with bylaws that are in disconnect to their CCNRs, because when you put an amendment that had a single proposition question that did not take into account anything other than a thumbs up for all or thumbs down for all, now you have this whole disconnect. You have CCNRs that are recorded that include owners of Section 7 as within the definition of owners. That's what you have. And
your view on whether those could just be amended?
You can't
you're
reform.
You're suggesting that you can't reform, that those other sections can't reform those documents?
The document that can be recorded is only what was approved. And the only thing that was circulated with approval, without any notion for any alternative, is the document where every section approved it, that includes a definition of owners as everyone, and there's no way of reforming it.
And just to make sure we're all on the same page, as we stand today, Sections 2, 3, and 4 cannot amend the CCNRs under the new set if they are valid, which the Superior Court says they were.
Not independently, right? They have to do it as a whole.
Okay.
So whereas Section 3 could have amended by a majority of example of whatever it is, 42 votes or so, right? They can't on their own. Now think about this. Section 2 that always wanted the mandatory membership has doubled the members. Okay? So now they now control, Section 2 itself now controls, if only Section 3 had approved, would control 2/3 of the votes. Now because Section 4 also squeaked by, now it's 50-50. But the point is that the 2007 CCNRs removes the ability to independently approve on a section-by-section basis, because the whole notion was to get everybody together, not to let section-by-section amendments. Hence why it cannot have been anything other than what we have said, all or nothing. The very statement that's the last quote things that quoted in our brief, the very last item, and it's we cut and pasted the text right from the CCNRs, gives you the history of the disputes involving this community. It references the 1985 matter, the 2004, and it says this does away with it. How can it do away with it if not all sections approve it? It's insane that we're arguing about what question was presented just because they could have done it differently. They should have then. And let's not ignore the fact it violates the single proposition on the ballot. If now what you're saying is that this was always to be, can Section 2 amend, can Section 3 amend, can Section 4 amend, and can the group as a whole amend the bylaws, and let's not forget Section 7, don't you have 5 propositions in one question? How do you get that accomplished under the voting requirements and the legislative very clear statute that you have to lay out 1 proposition per question? If that's what was intended, which is not what was conveyed, then the ballot is flawed. It's game over right there. It's flawed. It cannot survive. At a minimum, you have amending the CCNRs and amending the bylaws under 2 different criteria. And how does the proposition pass without being able to prove that the votes you counted on the bylaws were eligible votes? There is no proof on the record of that. That require a different standard. CCNRs, you have to be an owner. Bylaws, you have to be current. Unless the court is prepared to overturn the Wells Fargo Allen decision, the testimony saying that it comes in because I saw another document, it doesn't come in. There is no evidence that you have sufficient votes to pass the bylaw. So even if you want to say it's a single proposition, it has 2 parts. The second part of the single proposition didn't pass. It all has to fail. I'll reserve the remainder of my time.
Thank you, Counsel.
If it may it please the court, my name is James L. Sullivan, and I am the attorney for Sunburst Farms East, Inc. I wanted to make sure that a couple of facts are clear. As Judge Catani noted, there's no evidence in this case that anyone in Sunburst Farms that voted yes for the amendment understood that it was an all or nothing vote across all 4 sections. Okay? The only people that adopted that theory are the Braden defendants, and all of them either voted no or did not vote, which is the same as a no vote. Unlike a general election, in a community CCNR election, the total votes don't determine a majority. You have to have a majority of the homeowners. So any homeowner that doesn't vote because he doesn't care, out of town, busy, forgot, all is a no vote. So when a community obtains a majority vote, it's actually almost like obtaining a supermajority. And as such, These voters should not be disenfranchised. We were talking about Mr.
But what do you, what's your response to the argument that the vote doesn't make any sense, or at least in terms of the declarations, the bylaws as drafted are simply not workable unless all of the sections have passed by a majority?
I disagree. I think we need to bifurcate those issues into the bylaws and the declaration. As far as the declaration is concerned, we offered to file a notice of invalidity as to Section 7, but our offer was turned down. We think, I think, the Braden defendants wanted to come here with that open-ended and argue this, declaration reformation issue. The declaration.
How about the bylaws? Let's move to the bylaws.
The bylaws that they exhibited into the case, put into the case, that's EIR 1068. The original bylaws at the time of the election were inoperative. Duffy had already, the court in Duffy had already ruled that the good standing vote provision was inoperative, unenforceable. So in order to, let me get my thoughts together here. I apologize. The bylaws in existence at the time of the vote were inoperative because they were inconsistent with the CC&Rs. First of all, they said that everyone was a member and everyone in the entire community had to pay dues. Well, we know that's not true because in sections 3, 4, and 7, dues was optional, and if membership was optional in section 7. So the bylaws at the time of the vote were inoperative and they're ineffective, okay? The bylaws that were amended along with the CC&R amendment in the 2007 amendment apply and are consistent with the amendment in sections 2, 3, and 4. They would not apply to section 7 because section 7 didn't pass the amendment and therefore did not pass the bylaws. So they're left with the inoperative bylaws that they had before.
And section 2 is subject to mandatory assessments regardless of what happens here?
Originally, yes. Well, if it's invalidated, yes, they're still subject to mandatory dues, which was the unfairness in the entire community because Section 2 always runs the risk of having to bear the burden of any cost if there's a problem in the community, and the other lot owners.
Doesn't that undercut your argument entirely? Right now, Section 7 is freeloading on the other sections. So when you talk about unfair assessment, we're talking about all or nothing. If everyone passes it, everyone's subject to it. If everyone doesn't pass it, it's still unfair because some people are not subject to it and they're paying more than their fair share. Isn't that true?
I don't think it undercuts our argument. More fairness is better than less fairness.
But would you be here if there was only a majority vote in section 3 and not in section 4 in section 7? So we're only here we're going to have section 3 is subject to it, section 4 and section 7 are not?
Yes, we would, because each section, we have to interpret this ballot consistent with the amendment provision in the CC&Rs as prescribed by Duffy. Each section, at the time of the vote in 2007, could vote independently and had to vote independently to amend their section. In other words, let me put it to you simply. No one in Section 7 could vote for or against an amendment in Section 2. It was not possible. The CC&Rs are limited, and that amendment provision has been prescribed as anybody can vote in their section as long as they're an owner, and they don't have to be current on dues pursuant to the bylaws.
But how do we uphold a vote, though, when, as opposing counsel has pointed out, if you're told this is what you're voting on, it seems to be an all or nothing vote. This is how many votes are required in each section to get there, but it seems pretty clear that what you're voting on, and I realize we have an absence of evidence, but that doesn't really seem to be, we don't have affidavits from everyone who voted yes. I mean, we just have what appears to be something different than what was proposed to the people voting. They were told, if you vote yes, this means everyone will share in the cost, which is a different proposition than if you vote yes, you're going to pay a higher percentage now and it's going to be mandatory and other sections might not have to share in the cost. Sorry for the long question.
You're quite, it's quite all right. Sunburst Farms never told anybody in any handout or any statement that's disclosed in this case that if the amendment didn't pass in all sections, it would be ineffective in any section. In other words, they never specifically said it has to pass in all sections to be effective
You can't
in
draw
any
that
section.
inference pretty strongly from the bylaws as drafted?
No, I don't. From the bylaws?
From the CCNRs.
And what was proposed?
Are you talking about the statements made by the board, or are you talking about the proposed CCNR?
The proposed CCNRs.
The proposed CCNRs, well, here's the thing about that. They've got to be distributed to the community before the vote. So you can never know what the result of the vote is going to be before it's taken.
But you
so
could have presented different CCNRs depending on if it only passes in this section, this is what the CCNRs will be. If it passes in all the sections, this is what will be. And what in fact was presented was that what will happen if all of the sections vote yes.
I disagree that it was presented that way. I think it clearly states on the ballot that it identifies how many votes are needed in each section to pass the amendment. Plus, what I'm trying to explain to you specifically is defendant's argument is just an argument of interpretation. The Sunburst Farms never said those things. The CCNR amendment provision here, as prescribed by Duffy, requires each section amend independently. What Sunburst Farms was trying to do was put the amendment to all sections in aspiration that they would all vote for the amendment, but they could not know whether or not every section would pass it. There was no way to know beforehand. It couldn't be predetermined.
Absolutely, there was no way to know beforehand. But when we look at the words in the actual ballot, it says vote to amend, restate the declarations, covenants, conditions, and it lists all 4 sections. When we go to the CCNRs, it says property defined as all sections. That would be all 4 sections. So how do we get around the fact that this says all 4 sections, the CCNRs reference all 4 sections, adopting this document as the guiding principle of the entire group, not of Section 2, Section 3, Section 4?
Because at the bottom of the ballot, it specifically outlines how many votes were needed in each section independently to pass, number 1. That handles the ballot. When it comes to the declaration, it's just simply invalid as to Section 7 via the Shamrock case. It didn't pass in Section 7, so it's invalid and it never became in effect.
So is there anywhere that you didn't alert the voters that it required every section to pass for it to be effective, but is there anywhere you alerted the people that were voting that if one section passed, it would only be applicable to the sections that approved it?
Yes.
Where?
I think that's what it's saying here at the bottom of the ballot. Section 2 needs 41 votes to pass. If it doesn't get 41 votes, Section 2 will not pass. Same thing with Section 3, needs 41 votes. Without 41 votes, it will not pass. This is on page 19 of my answering brief.
I'm looking at the ballot right now. I
Right.
see what it says. We also have a statement from opposing counsel that somewhere it said it needed 145 votes to pass.
No one, well,
So
it would need 145
you
votes.
can argue either inference from just that statement. What I would like is your best evidence that says every section must pass this, or every section must individually pass this, and if they don't, they're not going to be subject to it.
What I'm trying to emphasize to the court is the ballot needs to be interpreted consistent with the CCNRs at the time of the vote.
And I don't disagree with what you're saying. What I'm saying is you have this ballot, you have these CCNRs that were provided. You've got to admit that defining property by all sections, how do we get over that? That's what I'm
Are you talking about the
with.
declaration or the ballot?
I'm talking about the CCNRs that we are adopting through the ballot.
The declaration.
Yes.
Well, as I said before, pursuant to the Shamrock case, the CCNR, the 2007 amendment, would simply not become effective in Section 7 because it didn't pass by the requisite majority. So it's just ineffective. And we offered to file a notice of invalidity regarding Section 7.
But is it also not invalid as to the other sections when it refers to property as all of the property, including Section 7? So how do we interpret the provision that talks about the definitions if
it's-
without excluding property in Property 7? In Section
If
7?
it's invalid as to Section 7, the property in Section 7 is precluded from the declaration. The declaration, the amendment just wouldn't apply to Section 7 because it didn't have the requisite vote.
So Section 7 gets to,
Remain under the first amended CCNRs, which allow optional membership and dues.
so you're
Nothing's
asking
changed.
Section 7 to voluntarily either become a member or voluntarily pay their dues, and the other three sections knowingly said, we'll foot the whole bill.
Knowingly said what?
We'll foot the whole bill. We're willing to pay for all of it, because in that proposition, we've got Section 2, who's already committed themselves. So this really didn't change the situation for Section 2, did it?
Not really.
Okay. So we got Section 2 that's already footing the bill. So each individual section had to say, we're willing to foot the entire bill, to
Right,
vote yes.
right.
And that's what you believe they did.
Right, because Section 3 and 4 are about 80 lots each. Section 2 is the smallest section, only about 40 lots, and about half of those people take the irrigation. So they're paying dues anyway. And remember, the purpose of the amendment was not only to try to bring as many lots as we could into the mandatory dues, and it's only an $18 a month dues to manage to maintain the infrastructure, but it was also to get rid of the halt judgment and the 2004 agreement. All those goals were accomplished. So out of the 280 lots, now we've got about 240 under one set of CCNRs. The halt judgment has been voided. The covenant not to execute has been ruled unenforceable, and the 2004 settlement agreement is ruled unenforceable. So this has been a big win here for Sunburst Farm.
How does that apply to Section 7?
Section 7 didn't pass the amendment, so, they don't want to pay mandatory dues, okay. But still, half of those lots take the irrigation and pay it as voluntary in any event.
And how many
And Section 7 might want to amend now to come in. In fact, they've talked to us about it.
How many lots are in Section 7?
42 out of 281 lots. I did want to make one point that Judge Catani might be familiar with. In your recent case of Reyes v. the Town of Gilbert, you effectively ruled that it was not a violation of Rule 26.1 for the defendant to not reply to a theory of liability that had not been disclosed. Here, the current on dues argument was first raised in reply, which I made a point of in our brief, but also it was never disclosed. You can check that in EIR 1057, Exhibit 12, which raises the Section 7 issues, but it's silent on the current on dues issue. So in order to invalidate the amendment on the current on dues theory, this court would have to, A, enforce a provision of the bylaws that the Duffy Court has already ruled are unenforceable, recognize that the current on dues was first raised in reply, and thirdly, acknowledge that acknowledge that that defense was never disclosed. So Sunburst really has not had a chance to work with an undisclosed defense or adequately respond to something that was first raised in reply. However,
that just goes to the validity of the majority vote in the individual sections, though, right? That doesn't address in any way the issue of whether a no vote in Section 7 invalidates the entire
amendments in sections
Right.
2, 3, and 4.
Right.
Right. Now, there our main argument is that, at the time of the vote, we have to follow the CCNRs that were placed in each section at that time. And Section 7 can't cast a vote for or against an amendment in Section 2, 3, or 4. And the board never made that statement explicitly. So what we got here is an argument, right? An interpretation argument when we know that the amendment provision in these sections has already been deemed by the Duffy Court to be unambiguous and no further inquiry is required. We shouldn't be analyzing a theory of interpretation on these particular CC&R amendment provisions, in our opinion. Do you have anything further?
Thank you, counsel.
Thank you.
Your Honors, first I'd like to correct myself. At the bottom of page 26 of our brief, and I quote, it says, a statement from the board that is not disputed. In order to adopt these revisions, we need a simple majority of 50% plus one vote from each section. So the statement, to the extent I didn't make it clear that they affirmatively said each section had to pass by 50% plus one, just to be clear, it's quoted at the bottom of page 26. Then on the top of page 28 is a similar statement that walks through the number of votes. So I kind of got confused with both of them, but then at the top of 28, it repeats it, 50% plus one. This vote was conditioned. It was conditioned upon approval by all sections. That's what occurred here. It doesn't matter what could have happened. To answer Judge Catani's question, I think the issue about the Rule 26 that was being raised only really goes to the current undos as it relates to the bylaws. It doesn't even apply to the CC&Rs, but if you don't admit one, you don't apply the other. The flaw with the argument from Sunburst Council is that the burden to prove the passage was upon Sunburst. When they filed their last motion for summary judgment, saying they had come forth with evidence to prove that enough votes were received, if you go back to the record and we cited, we objected. We objected there was no proof. They had inadmissible evidence seeking to prove the votes. That's all that was required. It was in the response. And that's where it got attacked. And then the notion that they offered to file a notice of invalidity just proves the point. It proves the case. You have CC&Rs that were recorded that do not conform to the vote. If they have an election, they're going to need to surpass the numbers from Section 7 because you need a majority of all the properties, including Section 7.
Those were recorded after they thought Section 7 had, in fact, passed by a majority.
That's debatable. They always knew they didn't have enough votes on Section 7. They didn't disclose it, but they knew they were short. Now, yes, that is correct. It's the exact set that was circulated that was recorded. And as Your Honor pointed out, they could have simply said the definition of owner is the owners of the lots of each section that passes. Okay, this recorded declaration will apply to sections that pass it. They could have done it in a million different ways. They could have had 4 separate sets of CC&R that were exactly identical, with a provision that to the extent passed by each of the sections, they would merge into one. They could have been so many ways of doing it. Instead, they chose to do it with the statement, in order to adopt these revisions, we need a simple majority of 50% plus one vote from each section. That ends the case.
Thank you, counsel. We thank you both for your arguments this, I guess it's morning. We will take this under advisement and issue a written ruling in due course. Please take care of yourselves. Be safe. We are at recess.